Calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andres Mejer.
Now, let me give you two examples of immigrants that were inadmissible because they had an order of deportation. Two different scenarios. We filed for two different sets of waivers, and both of them today have their green card. So let's talk about Irma. Obviously, like I always say, the names I'm using are not real, but the cases are. These two are my clients who I helped, and I'm going to explain to you how we helped them. So Irma, pastor brought her to us days before she had to present herself for ICE. The note said, bring your tickets, you're gone. You need to leave the U.S. She had 5 kids, 3 born in the U.S. Now, she was in here, undocumented, under the radar, went back to her home country to bring her kids, was caught at her 2 other kids, was caught at the border. All 3 of them were put in removal proceedings, were allowed to come in. She didn't appear for court, and she and those 2 kids were giving orders of removal. Now, she went to a prior attorney and got some really stupid advice, and that attorney said, yeah, don't go to court. You're just going to get deported. Well, that's exactly what happened when she didn't go to court. She got deported. She actually had a pretty strong case for asylum, but she lost it when she didn't file timely within a year, number one, and when she didn't present herself in court and was given an order of deportation. Really, really stupid advice. Unfortunately, not all attorneys are the same. Now, as it so happens, the oldest of her 5 kids was a victim of a really heinous crime here in the U.S. This same attorney applied for the U visa for the victim, who was a minor, and then derivative to him was mom and his younger sister. Because he was under 21, his mom and his sister can both qualify, even though they weren't the direct victims, he was. Now, this attorney royally screwed up. She didn't submit adequate proof that mom was mom. I don't know how she did it, but she sent the wrong birth certificate. It had the wrong information. And USCIS reviewed it and said, hold on a second, we're requesting more evidence because this birth certificate has nothing to do with these people. Please give us the real birth certificate. She never responded. Her U visa petition was denied for mom and sister. For oldest son, who was the victim of the crime, he qualified. Not only did he qualify, he actually got his U visa. And mom, Irma, was presenting herself to ICE once a year, every year, with, and they would ask what's going on, and she would say, my attorney did this, my attorney did that. Attorney didn't do squat at the end of the day. Trump came in, I said, you know what, you've had 5 years, we're not giving you any more time, come back with your tickets, and you're gone. Came to us 2 days before, we evaluated, we went with her to the ICE officer, they gave her more time. We filed a new U visa petition. The visa was already current because she was derivative to her son's petition, and her son's petition was already approved. So we knew there was a visa, we knew she qualified. All they needed to do was prove the mother and son relationship. Look, in every scenario, we know who the mother is. We don't always know who the father is. And the fathers in some countries don't always register their children. I've talked about in this program in the past about a client of mine who was married to a U.S. citizen, ultimately got divorced, but got his green card. Went right after he got his green card, he went to visit to his home country, was meeting with his family, met one of her sister's best friends. They had a really good time that night. A couple days later, he came back to the U.S. 10 years goes by. That sister's best friend has a 10-year-old son, dies of cancer, and tells her sister, your brother is the father of my child. He had no idea he even had a child. He had no idea she was pregnant. He goes, he applies for son, brings him in, they're together. Now, obviously the son, if you look at the birth certificate, it didn't include the name of the father. Father didn't even know. He legitimized that relationship. It is his son, and his son is now a green card holder and probably by now already a U.S. citizen, just like dad. So we filed a new petition We went with her to ICE. Because she had an order of deportation, ICE rushed the review of the case. It was approved, and because the visa was already available, because her son had already had a U visa for years, she was able to get the U visa. Now, son can now apply for residency, for his green card. She should have done it already, but we were waiting for mom's situation to be resolved. So the fact that she had an order of deportation was overcome by the waiver that the U visa includes. Let me give you another example of George and Maria. Here we had to do multiple waivers. George came to the U.S. from the Dominican Republic. He filed for asylum after a couple of hearings. He didn't appear, and he was ordered deported. Years later, married a U.S. citizen. He was pulled over by the police, and they found his order of deportation. They detained him. His wife contacted us. We did what's called a stay of removal, stopped the deportation. It allowed him to come out of detention under certain conditions. Initially, it was an ankle monitoring. Ultimately, we got that to go away. Wife was a U.S. citizen. They were married. She filed for him for his I-130, it's called an immediate relative petition. We got that approved. Then we had to file for a waiver, an I-212 specifically, because we had to overcome the order of removal. We did the I-212, got that approved. Once that was approved, we then had to file the unlawful presence waiver, the provisional lawful presence waiver. So when he came to us, he was inadmissible to the U.S. for two reasons. It was he had an order of deportation, which he failed to appear. Automatically 5 years, he can't adjust. No waiver for that. But he was past the 5 years, so we didn't have to worry about that. We just had to worry about the fact that there was an order of removal. Second was he entered without permission, and he was here for more than 1 year. So if he leaves, he's inadmissible for 10 years. So two things. We filed the first waiver, the I-212, to overcome the order of removability. Once that was approved, we then filed the 601A waiver to overcome the unlawful presence. It's stupid. It would have been much easier, much more, if we could have filed for both at the same time. But because the way the law is, we could not. So we had to file for one, wait for months, then file for the other, wait for months. Then he consular processed. That means he got an appointment at the U.S. Embassy in usually his home country. Doesn't always have to be. He went, he was interviewed, and he was allowed to come back in as a green card holder. So order of removal still exists, but now it's been waived, and now he's a green card holder. Now, when this process started, his wife was expecting a child. Now they have 3 kids. It took years. It took thousands and thousands of dollars. No question about it, probably over 20,000, over 25 for during those 5 years. Multiple ICE visits, multiple motions, multiple interviews with immigration, not to mention filing fees, leaving the U.S., come back, doctors, experts. It was complicated. But at the end of the day, he's a green card holder. Thank you very much for listening to our program. Don't forget to please subscribe in the bottom. And if you have any question, and hit like. If you have any questions or any issues you want us to talk about on this program, I'm happy to do that. Just send me a message, privately or otherwise.